So this just got personal. I woke up to something absolutely surreal. Blake Lively's attorney Ezra Hudson just subpoenaed Google for access to my Gmail account. Yes, you heard that right. I, a journalist and independent commentator, received an official notice from Google telling me that unless I file a motion to quash by 10:00 a.m. on July 31st, they're going to hand over my information. It was 3:56 p.m. when I got the email. Just a completely normal day until then, and now suddenly I'm part of what appears to be a massive fishing expedition. Let me back up. The case in question is Blake Lively versus Wayfarer Studios, and somehow my name got caught up in the chaos. The notice didn't include the actual subpoena or any specific explanation of what data they want, which is weird. It's not like I'm hiding. My name is Katie, and I've always been transparent about who I am. So what exactly are they hoping to find in my Google account? I have no idea. And let's be real, what are they expecting to uncover in my inbox? I've never spoken to Brian Friedman. I've never communicated with Justin Baldoni, Steve Sarowitz, Jamie Heath, or any of the other named individuals in this case. None of them have ever contacted me, nor have they paid me. I've never been hired or even approached by any party involved. I get my information the same way any decent independent reporter does, by analyzing publicly available court records, engaging with anonymous but unrelated sources, and following the story as it unfolds. That's it. So why is Blake Lively's legal team reaching into my Google account? Are they looking for my search history, trying to see if I Googled something about the case, hoping I accidentally emailed a key player without realizing it? Maybe they're trying to dig up personal or financial data like YouTube revenue to suggest that I've been paid off to report on this case. Spoiler alert, I haven't. If anything, I'm losing money. I recently received the largest Pacer bill I've ever gotten for $1,700 just for accessing court documents over the past 3 months. So no, I'm not part of a conspiracy. I'm not in contact with any of the parties involved. I'm just doing my job as a reporter. So here we are, and I honestly can't believe I'm saying this, but I've just been subpoenaed by Blake Lively's attorney. Not a cease and desist, not a warning or a correction request. An actual subpoena served to Google for my Gmail account. Why? Because I covered a public legal case using public records and court filings that anyone could access, because I analyzed evidence that was voluntarily filed in court, and because apparently asking questions about inconsistencies in Blake Lively's story now makes you a threat, a target, a problem to be silenced. It was just a normal afternoon when I received the email from Google. 3:56 p.m. The subject line alone gave me a jolt. It said that Google had received a subpoena in a case titled Blake Lively versus Wayfarer Studios, and not just that, they might hand over information about my Google account unless I filed a court-stamped motion to quash by July 31st at 10:00 a.m. Pacific. I stared at the email stunned. What information were they even asking for? What did they expect to find? The email didn't even include a copy of the subpoena, just the notice, and it listed the name of the person who issued it, Ezra Hudson, one of Blake's attorneys. Now let's get something clear from the beginning. I'm not hiding. I use my real name. I operate a legitimate LLC registered in the state of Minnesota. I've always followed proper legal and ethical procedures when reporting on this case and others. So again, what is the purpose here? If someone on Blake's team had a question about my coverage, they could have contacted my legal representation. In fact, they've done that before. One of Blake's attorneys, Kristen Toller, sent a cease and desist letter to my home certified mail overnight. They know how to reach me. So why go to Google? Why try to pry into a Gmail account I barely use that contains no communication with anyone related to this case? No hidden documents, no conspiracies. The email account they subpoenaed is the one linked to my YouTube channel. It's not my business email. It's not my personal email. I don't use it to talk to sources. In fact, it mostly gets junk Patreon updates, real estate alerts, and marketing spam. I don't even have location tracking turned on in that account because I find it invasive. If they were hoping to find a smoking gun, they're going to be sorely disappointed. There are no payments from Justin Baldoni, no secret messages from Brian Friedman, nothing but receipts and bot traffic. And if their theory is that I'm somehow being paid off by someone involved in this lawsuit, I'd like to ask this. Why would I spend over $4,700 in PACER fees in just 3 months to access federal court records? If I were a shill, wouldn't someone else be footing that bill? So let's talk about how we got here. I didn't cover this case until late January or early February. Why? Because I didn't feel comfortable talking about it at first. I wanted more information. I wanted to see both sides. In the beginning, I believed Blake. I gave her the benefit of the doubt. Even when the now infamous dance rehearsal footage came out, I tried to interpret it from a place of empathy. I've been through trauma, I know how it looks, how it feels. I thought maybe she was pulling away from discomfort. Maybe there was something not captured on camera. I wanted to believe her. I wanted to extend that grace. I didn't speak out. I didn't speculate, but then the filings started. Wayfarer Studios filed their official complaint and included evidence, text, emails, call sheets, production logs, and that's when I began to take a closer look. The more I read, the more I watched, the more it all just stopped making sense. I watched the movie, including the so-called controversial birth scene, and was shocked at how tame it was. Blake wasn't naked. She wore a full hospital gown, shorts, and a prosthetic belly. There was no nudity. The camera angles didn't exploit her. If anything, it was so medically framed it felt emotionally sterile. And when I saw the still photo from that same scene, the one that was called pornographic, I actually said out loud, this is what she's calling explicit, because it wasn't. It was basic, clinical, staged, and don't even get me started on the sex scenes. The book this movie is based on, it's filled with graphic sexual content, very detailed scenes. Compared to that, the film is practically Disney level. I saw no exposed breasts, no full nudity, no shots below the waist. The most provocative moment was a scene in bed where a hand slides up a thigh fully clothed. And yet the lawsuit framed it as coercive, excessive, over-sexualized. It didn't add up. I kept thinking, am I watching the same movie? Are these really the scenes we're calling abusive? And that's when I realized this case needed to be scrutinized with the same rigor as any other public lawsuit. Which brings me to the legal aspect of this. One of the biggest red flags in Blake's filings is the implication that conversations about filming sexual scenes, if held by men or relayed by a director, automatically qualify as harassment. But how else are these scenes supposed to be choreographed? This is how films are made. There are intimacy coordinators for a reason. If Blake didn't want to speak directly with the intimacy coordinator and insisted on communication through the director, then it makes sense that he would relay those notes. That's not predatory, that's compliance, that's management. You can't have a scene without discussing the scene. You can't have a simulated sex scene without simulating something. This is not new. This is not unorthodox. This is how film production works. And yet now we're supposed to pretend that even mentioning the word intimacy is a violation. That somehow the creative process itself is evidence of misconduct. And so I started asking questions, not because I had an agenda, not because I wanted to bring someone down, but because I couldn't make the facts match the allegations. I compared the complaint to the movie, I compared the claims to the court filings. And the more I compared, the more glaring the disconnect became. So I reported on that. I spoke on that, I analyzed what I saw, I engaged with legal experts and readers and followers. And yes, I had sources, anonymous sources unrelated to the core parties, but still offering insight. And no, I won't be revealing those sources. I'm a journalist, I'm protected. And trying to subpoena my Gmail in an attempt to dig up those names, that's not going to happen. This is a pattern we've seen before. Public figures filing lawsuits and then panicking when public opinion doesn't follow their script. But that's the risk you take when you go to court. You make it public, you file those documents. You turn your grievance into a legal process. And with that comes media attention, criticism, and investigation. You don't get to pick and choose which parts of your case the public is allowed to talk about. You don't get to tell reporters to only highlight the evidence that supports your version of events. And you definitely don't get to subpoena journalists just because they pointed out the gaps in your argument. So what exactly is Blake's team trying to find in my Google account? My name is attached. My phone number, that's not private. It's all on public record. My address isn't even associated with that account. I don't store sensitive data there. I don't track my location. I don't use it to correspond with sources or legal contacts. So are they hoping to find search history, legal research queries? Guess what? I Google court terms. I look up motions, statutes, filings, procedural deadlines. That's part of my job. That's how I stay informed. That's how I produce accurate, reliable commentary. If that's incriminating, then I suppose every legal analyst on the internet is guilty of something. But the most disturbing part of all this is the precedent it sets. If Blake Lively's team can serve subpoenas to every content creator who questions her case, what happens next? Do we start censoring commentary? Do we criminalize analysis? Do we stop people from discussing court records that are freely available to the public? That's not just dangerous, it's un-American. It undermines the very foundation of the First Amendment. It sends a chilling message to every journalist, podcaster, and content creator: stay silent, or we'll come for you. Well, I won't be silent. I'm not going to be quiet just because someone with more money and legal power thinks they can throw their weight around. This is still a democracy. We still have press freedom. We still have the right to speak critically about public figures and public matters. And I will exercise that right without fear, even if it means going up against someone with Hollywood clout and a fleet of lawyers willing to throw subpoenas like darts at a board. What's happening here is outrageous. I'm not the only one. Multiple other content creators have received similar notices from Google. All within the same short window. It's a coordinated move not to seek justice but to intimidate, to harass, to control the narrative by creating a climate of fear. Let's call it what it is, a digital witch hunt. One by one, voices that have dared to challenge Blake Lively's version of events are now being dragged into this courtroom, drama under the flimsiest of pretenses. It's not about truth, it's not about justice, it's about punishment, retaliation. If she can't silence people with legal threats, she'll try to bleed them financially. Subpoena their data, force them to lawyer up, and hope they back off out of fear or exhaustion. But here's the thing, I've faced worse. I've covered people more powerful and more dangerous. I've been sued, I've fought back, and I'm still here. What strikes me the most is the sheer hypocrisy. Blake Lively entered this lawsuit claiming she was a victim of exploitation, of being silenced, of being mistreated. But now that the public is asking questions about her claims, her legal team is turning around and exploiting the very same system she says betrayed her. They're abusing discovery tools. They're trying to subpoena unrelated third parties. And they're doing it with a smug air of entitlement, as if they're untouchable, but they're not. The courts aren't playgrounds, and journalists aren't pawns. I find it particularly troubling that this subpoena was filed just one day before Blake's legal team was due to update the court about third-party production deadlines. The judge had already made it clear all discovery from third parties must be completed by July 25th. So why did this get served on July 10th with a compliance date of July 31st? It doesn't line up with the court's timeline. It feels sneaky, like they're trying to slip this in under the radar, delay disclosure, and then blame third parties like Google for not turning over records in time. But here's the kicker, what records? They haven't even explained what they're looking for. I haven't received the subpoena itself, just the notification. There's no explanation, no scope, no justification, nothing that would indicate what exactly they expect to find. It's all just guesswork. That's the hallmark of a fishing expedition. You don't have a lead. You don't have a connection. You just throw out nets and hope you catch something. But journalism isn't fishing. It's research. It's verification. It's responsibility. And subpoenaing my account won't change the facts. It won't rewrite the court record. It won't erase the contradictions that have already come to light. And it certainly won't stop me from talking about what's already public, because that's what this all stems from. I read what Blake's team filed. I read what Wayfarer's team filed. And I noticed a difference. That's it. That's the big scandal. That's what triggered this legal tantrum. I noticed that the complaint didn't match the evidence. I noticed that the movie didn't match the allegations. I noticed that the definition of sexual harassment didn't match what was described. And instead of addressing those discrepancies, Blake's team decided to attack the messenger. Let's revisit some of the facts that made me question Blake's story. The dance rehearsal footage, the one that shows her moving freely dancing with others seemingly comfortable, is a key piece of evidence. If her lawsuit claims she was coerced, humiliated, and victimized during that very shoot, then how do we reconcile that with what we see in the footage? If she was traumatized, why is there no visible distress? Why is she laughing, chatting, engaging? Trauma responses vary, yes, but the lawsuit describes a very different atmosphere than what's captured on tape. That matters. Then there's the issue of the birth scene, arguably the most controversial part of her claim. She alleges it was shot without consent, that it was exploitative and sexually charged. But the footage says otherwise. She's clothed, she's covered. There's no nudity, there's barely any intimacy, and it's filmed with clinical detachment. If this is the basis of her claim for harassment, then the standard for what qualifies as misconduct is being stretched beyond recognition, and I get it. Talking about this makes people uncomfortable. Nobody wants to accuse someone of exaggerating trauma. Nobody wants to say, I think this person might be manipulating the facts. But when the facts contradict the narrative, we have a duty to point it out. That's how journalism works. That's how the truth comes out. And if that makes people uncomfortable, so be it. I would rather be uncomfortable than complicit in a misinformation campaign. So now let's look at this from a legal perspective. If Blake Lively's team genuinely believes there is defamation occurring, then the correct path is to file a separate defamation lawsuit against specific parties. That's how the system works. You don't use discovery in an unrelated civil lawsuit to gather evidence for a potential future defamation case. That's an abusive process. That's using the courts as a weapon. That's not justice, that's vendetta. And I know this because I've covered dozens of cases where public figures tried the same tactic. File a vague subpoena, demand all communications, demand metadata, demand financial records, and then hope to uncover something that could justify their outrage after the fact, but it rarely works. Judges see through it. Courts protect journalists. And public backlash builds when these tactics come to light. That's what's happening here. Blake's legal team is betting on the idea that we'll be too afraid to speak. But they're wrong. We're just getting started. What's even more disturbing is how this plays into the broader conversation about press freedom. We live in an age where content creators are becoming the new media. We analyze, we investigate, we challenge powerful people. And legacy celebrities are terrified of that because they're used to controlling the message. They're used to puff pieces and friendly interviews. But YouTube creators and independent journalists don't play that game. We look at the receipts. We follow the paper trail, and we tell the truth as we see it, even when it's messy. That's why these subpoenas matter, not just for me but for every voice that challenges power. If Blake Lively's legal team can subpoena journalists for simply discussing court filings, then what's next? Will they subpoena Reddit users who post threads, Twitter accounts that repost quotes, TikTok creators who stitch a clip and ask questions? Where does it stop? The answer is it doesn't. Not unless we push back, not unless we expose what's really going on here. And so that's what I'm doing. I'm telling the truth. I'm showing my work. I'm inviting transparency. If Blake's team wants to argue that my coverage was biased or inaccurate, they're welcome to provide evidence, but they won't find it in my Gmail account. Because my reporting is based on facts, not speculation, not rumors, not paid incentives. And if they had taken the time to read my work instead of trying to invade my privacy, they'd know that. Let's also talk about how I've handled this story compared to others. I've never called Blake names. I haven't mocked her appearance, her voice, her children, her family. I don't engage in tabloid-style trash talk. I refer to her respectfully, either by her full name or as Miss Lively. I don't use derogatory nicknames. I don't speculate about her marriage. I focus solely on the facts of the case and the material in the court record. And yet I'm the one being dragged into this legal circus as if I'm part of some smear campaign. Do you know what this really is? It's punishment for not buying the narrative. It's retaliation for asking inconvenient questions. And it's designed to send a message: don't challenge us or we'll come for you next. But that message won't work here because I have a team, I have legal protections, I have a platform, and most importantly, I have the truth. The truth that Blake Lively voluntarily put this case into the public domain. The truth that her complaint contains inconsistencies. And the truth that journalists have a constitutional right to report on public cases regardless of whether it makes the plaintiff uncomfortable. So Blake, if you or your attorneys are reading this, let me say it plainly. You will not find anything in my Google account. I have never spoken to your enemies. I have never received a dime from Wayfarer Studios or their attorneys. I have not participated in any smear campaign. I have analyzed your case the same way I analyze every case, critically, fairly, and based on facts. And if your goal is to discredit me, I invite you to try in court with evidence, not through backdoor subpoenas and intimidation tactics. Because here's the thing you forgot: this isn't just a lawsuit, it's a moment, a turning point, a test of whether independent journalism still matters, and I plan to pass that test. This entire ordeal has exposed far more than Blake Lively ever intended. What started as a high-profile lawsuit over a film has now spiraled into a much broader conversation about media power, intimidation, and the boundaries of truth in the digital age. By trying to control the narrative through legal threats and overreaching subpoenas, Blake and her legal team have revealed a side of the Hollywood machine that many people suspected existed, a side that values image over integrity and control over accountability. And yet, what's happening now goes beyond just her case. It sets a dangerous precedent for how celebrities or anyone with resources and influence can weaponize the legal system against people simply doing their jobs. Journalists, commentators, creators, we're not publicists. We don't owe celebrities flattering portrayals. We owe our audiences the truth, and when the truth becomes inconvenient for the powerful, we don't run, we report harder, we speak louder. The subpoena I received wasn't about evidence, it wasn't about justice. It was about fear that the narrative Blake tried to construct was crumbling under the weight of facts. Fear that the public was no longer buying her version of events. Fear that independent voices had too much power, and maybe we do. But that power comes from honesty, from transparency, and from a refusal to be bullied into silence. Let's be clear, I'm not going anywhere. Neither are the other creators who were targeted. We're not going to back down, and we're not going to stop reporting. If anything, this has energized us. It's reminded us why we do what we do. We're here to protect the truth, not just for ourselves, but for everyone watching. Because if someone like Blake Lively can abuse the legal system to try and muzzle dissent, then who's next? This is the story now. The subpoena has become the evidence. The attempted censorship is the scandal. The backlash is the consequence. And Blake Lively, whether she realizes it or not, has lost control of this narrative. Not because we stole it, but because she gave it away the moment she tried to silence critics. Instead of answering their questions, I didn't choose this fight, but I won't walk away from it either. Because there are lines that cannot be crossed without consequences. There are principles that cannot be surrendered without a cost. And there is a truth here beneath the glamour and the legalese that demands to be seen, heard, and understood. And that truth is simple: if you sue your way into the spotlight, you don't get to act shocked when people start looking at you under a brighter light. No matter how many subpoenas are sent, no matter how many lawyers are involved, the truth is out there, and we are not afraid of it.